I'm here this evening to commemorate the passing of a remarkable individual. I only met her once when I went over to speak at a gathering of the United States District Court for the District of Columbia. But on March 16th, at the age of 85, Her Honor, Judge Gladys Kessler, passed away. She had been quite a trailblazer before she went on the court. She co-founded the Women's Legal Defense Fund, now known as the National Partnership for Women and Families, and she served as the president of the National Association of Women Judges. In her career, she rendered a lot of very good decisions, but the most memorable one, and the one that exemplified some of the characteristics I admired the most about her, was the decision that she rendered exposing in detail a conspiracy by the tobacco industry to deceive the American public about the safety of tobacco. The big tobacco scheme is one that we're, I think, pretty familiar with. You pay a lot of phony baloney for-hire scientists to produce studies making false claims about your product. You hire a web of PR experts and front groups to spread doubt and critique the actual real science that you don't like. And you have paid intermediaries relentlessly attack and try to smear your opponents. In the face of this behavior, we had a remedy: the Racketeer Influenced and Corrupt Organizations Act, the RICO Act. In 1999, the United States Department of Justice filed a civil RICO lawsuit against the major tobacco companies and their associated industry groups, alleging that the companies, and I'll quote the complaint here, engaged in and executed and continue to engage in and execute a massive 50-year scheme to defraud the public, including consumers of cigarettes, in violation of RICO. The case took 7 years, but in 2006, Judge Kessler wrote one of the most impressive opinions I've ever seen from a United States District Court judge. It was 1,683 pages long. She went through the evidence that the United States Department of Justice had marshaled, and she organized it and laid it out in a way that was completely compelling, that completely crushed the defendant tobacco companies, to the point where, when it was on appeal, the U.S. Court of Appeals for the D.C. Circuit very powerfully upheld it. It is one of the powers of a district judge that, with the authority to find the facts and marshal the evidence properly, you can make virtually bomb-proof opinions. And in 1,683 pages, Judge Gladys Kessler did just that. She found that here's her quote: "Defendants coordinated significant aspects of their public relations, scientific, legal, and marketing activity in furtherance of a shared objective to maximize industry profits by preserving and expanding the market for cigarettes through a scheme to deceive the public. In short," she added, "they have marketed and sold their lethal product with zeal, with deception, with a single-minded focus on their financial success, and without regard for the human tragedy or social costs that success exacted." It was a testament, this opinion was, to judicial diligence. And it left a permanent, solid record for history of the campaign of fraud that the tobacco industry had run until that point. Of course, in order for her to be able to render that decision, there had to be a plaintiff willing to bring the case. So kudos also to the United States Department of Justice back then for being willing to take on a defendant as powerful as the tobacco industry then. We forget now that smoking is so much less of a thing, how enormously powerful the tobacco industry was, how its network of suppliers gave it footholds in every state, how its enormous revenues allowed it to come into this building and manipulate the politics of the United States Congress to the great detriment of the health of the American people. It goes without saying that there is an obvious parallel between the conduct of the tobacco industry leading up to Judge Kessler's decision and the conduct of the fossil fuel industry. In fact, experts point out that when Judge Kessler's decision shut down the fraud of the tobacco industry, some of the individuals and some of the organizations that have been involved in that fraud simply rebooted themselves as new experts in how to deny climate science. I hope that we come to a point where today's Department of Justice has the diligence and the fortitude to go ahead with a similar action. But today, this is about Judge Kessler, a woman who saw something going very badly wrong and sat down and wrote a 1,600-page decision to put it right. I think it's a pretty terrific example, and I have a few bits of business, if I may, and then we'll open the floor to the other speakers. I first need to ask unanimous consent that the appointment at the desk appear separately in the record as if made by the chair.
Without objection.
And I ask unanimous consent that the Committee on Health, Education, Labor, and Pensions be discharged from further consideration. And the Senate now proceed to Senate Resolution 123.
Clerk will report.
Senate Resolution 123, recognizing the week of March 19 through March 25, 2023 as National Poison Prevention Week, and so forth.
Without objection, the committee is discharged, and the Senate will proceed.
I ask unanimous consent that the resolution be agreed to, the preamble be agreed to, and that the motions to be considered made and laid upon the table.
Is there objection? Without objection, so ordered.
Finally, I ask unanimous consent that when the Senate completes its business today, it stand adjourned until 10 o'clock a.m. on Tuesday, March 28th, that following the prayer and pledge, the morning hour be deemed expired, the journal of proceedings be approved to date, the time for the two leaders be reserved for their use later in the day, and morning business be closed. Following the conclusion of morning business, the Senate resume consideration of calendar number 25, S316, post-cloture. Further, at 11:30 a.m., the Senate vote in relation to the Johnson Amendment number 11 and Ricketts Amendment number 30, that the Senate recess following the Ricketts vote until 2:15 p.m. to allow for the weekly caucus meetings. Further, at 2:30 p.m., the Senate vote in relation to the Cruz Amendment number 9 and Sullivan Amendment number 33, that at 5:15 p.m., the Senate vote in relation to the Scott of Florida Amendment number 13 and the Hawley Amendment number 40, and finally, that all previous provisions in relation to the amendment votes remain in effect, and with 2 minutes for debate, equally divided prior to each vote.
Is there objection? Hearing none, so ordered.
If there's no further business to come before the Senate, I ask that it stand adjourned under the previous order following the remarks of Senators Cassidy, Rubio, Sullivan, and Brown. I yield the floor.
Without objection.